Okay, so I'm ready to conduct the lecture. Good afternoon, ladies and gentlemen. Have you finished your midterm exam? Now we in the second half of this term, perhaps many works to let you go further through winter vacation. Okay, in this class you'll have some introduction about administrative materials. My focus is on state materials, so state administrative materials. So perhaps it will be in weeks when we enter a online material. So perhaps in next week we'll explore local laws. That will be final. So in for the primary legal resources, and will be complemented in weeks about with other topics, online legal resources and some globalization and legal problems. So perhaps I expect a little easy journey in this term, and might collaborate to explore some of paragraphs and pages of classics for your basic comprehension of a common law system. Okay, then for this class you will have some ideas about the basics. You have some work on this class. I outline the epitome of this class in the first place. Last week we explored federal regulations and analyzed the impact on policy issues. What happens in a practical sense if the language of regulation, the jargon, isn't clear? What if can support different legal outcomes and is interested in different ways? How the drafters of legal documents avoid these problems? This week you explore the answers to these questions, this time exploring state regulations. You also consider approaches to regulation reform. So take a chance to visit, for example, the website of a state of Illinois. Then perhaps some ideas. And what actually happens in the website will lead you to some fairly organized information about state materials. First, you see some guidelines, what they often called executive orders or administrative orders, announced by Office of Governor. That will actually the kind of some leading command about the executive branch. And you also have some information about the process of enactment in the legislature, and you will have some legal information about judicial branch. And the same reality would be found in the pages, which means you will see different types of bills or statute or session laws and archives of types of materials will let you to your notice. And so, of course, that would be according to the FOIA, the government is responsible to the information, public information on public notice. The public disclosure would be mandatory in some cases, and might be recommended in promotion of sharing and the kind of a public relations to be necessary about a paradigm of liberal government, democrat, but actually the rules and administration are required to conform to the values of democracy. So we have some important concept from the Constitution, due process of law, and you also have an awareness about APA procedure, command, notice and command requirements. So Federal Register would be a forum, and also many procedural requirements about public forum or conference, or the kind of opportunity to be heard of adjudication or decisions. So the kind of rules which is essential to legalize, which actually affect our public lives. And through this class, I encourage you to have some outcome, learning outcome, and for class progress, you should be able to interpret state regulations and analyze approaches to regulation. So the concept is the importance of interpretation. For example, about state regulations. Actually, the state would have enacted but often they would manage a little feeble context of this when we reach to the dimension of state regulations. So they enact a statute, for example, and also complement it with the order of a governor or others, and also may have some rules from judicial branch, and of course many areas of state government interest would be dealt in state regulations. Take a look at the code and statute of public health, or labor union, and business and professional organizations. You will see subject matters often shared by many states in the website. Then they would put the relevant legal materials in terms of authority, in some sense hierarchy, to be a resonant among others. Lawyer or might be subject to kind of control. So it should not contradict the higher norms. In legal terms, the authority would define the scope and fashion about this. So actually, in every conflict, we'll see some sensitive eyes to identify its true effect. It's many cases it is in practice that the court would not consider it the kind of norms. So it might be treated evidentiary or the mere fact. So you will see a similar concept in the areas of international law. So foreign laws would be disputed, whether it is law or fact. So, that would bring some different context of legal effect as a matter of practice. Notably, you will see some limitations about appeal to the Supreme Court. For example, there will be a same between the United States and Korea, for example. So only the cause which arises from interpretation of state law. So legal issues qualify for review of Supreme Court. They will be based on many public rationales, as you can see. So case law, heavy case law would require certiorari and some statutory limitations on the scope of legitimate appeal. So if the state regulations would be classed as a fact, consider if the effect would be on the context of appeal. So that would not constitute any statutory qualification to be appealed to the Supreme Court. So how do you consider its exact identification about legal quality? So it's fact or a law. In other aspect, the law is binding and objective. So it actually applies notwithstanding the specific intention of parties. So there will not be matter. Actually, when we determine if it should be applied or not. However, take account the other version, that the state regulations is mere fact, then it is the responsibility that the councils and parties should argue to locate its existence, and should argue to urge the court attention. And if they fail to address its consequence in cases above, then they could not dispute it anymore. So what does it mean? Actually, the consequence is real, not hypothetical. Nonetheless, in other cases, the court say state regulations are law. So interpretation is kind of serious matter, as analogous to the legislative acts. And so the kind of discussion and scope and principle would be shortly indebted to the article titled "How Court Interpret Regulations." The article was authored by Frank C. Newman and featured in California Law, and a fairly old article, antedated as far as in 1947. Nonetheless, the article is quite classic in comprehending the problems and the court practices and some important aspect involved in interpretation of state regulations, or exhaustively a survey. So, and what actually they also spelled out many important points, practically useful. So we have a time of a brief review of this article. And also you need to have some ideas about the analysis on the approaches to regulation reform. So you may work as a public officer in government branch or local administration, for example, Gwangju province in the United States. Then you have many opportunities to be entangled with regulations and its interpretation and amendments. Actually, most effective way to counter the challenges arising from the regulations would be shape some amendment. Interpretation is quite meager in a sense, as I stated, since that will not be seriously taken account in the court as a law. So they see it evidentially, or what was shifted, kind of vulnerable to many arguments or facts posed in a different perspective of view, so challenging. So it would be wiser to create amendments and attach. Actually, I consider some classification about amendments, additive, or in some cases you would delete the existing phrases, or you will change by different words to clarify its meaning. So it's a kind of journey to the true meaning of statute. In that case, we see two ways between interpretation and amendment. I suggest amendment would fulfill more effectively and might reduce mitigated chances of litigation. So it would not be good actually for the public administration to buy a litigation, and they would expend much to respond with a court proceeding. They would buy expert testimony, for example, and prepare a memorandum in some cases, and court brief to argue in favor of its case is actually burdensome. So prevention would be a strategy, and in that case, I suppose amendment will yield a better result. And the article also exploit that point. So the author has two set of contrast between what the interpretations are look like amendment, and when interpretations look like amendment, what problems do actually occur, kind of question. And in opposite aspect, you consider that means when the interpretations are not like the amendment. In that case, how do you perceive interpretations work? And also what principles have been employed by court in disposing their specific case? And kind of a question well developed in brief context. And in that endeavor, you will have some points to enhance your position. First, you'll be the better to reflect on the state regulation you will use and consider the implications of the regulation as you interpret it, noting any potential issues that might arise in its enforcement. And think about what approach you might take to reforming the regulation if you are an administrator in the agency from which the regulation emanated. And consider this paragraph about interpretation of regulations. Regulations often require interpretation, just as text do. Some are written hastily or in an unclear manner. Others are filled with legal jargon, making it difficult for the people affected by them to understand. So, in the article delivered in the class, you'll find many Latin words and also state regulations may employ kind of words, gobbledygook, legalist, difficult words we routinely missing in use. It means legal jargons, gobbledygook, legalist. Consider, for example, what does it mean? Narcotics, used in the statute by Federal Drug Administration. How do you define the terms? What does it mean? Nicotine, what does it mean? And many medical words to support and define the aims and provisions of a public health statute. So what actually the context is also hierarchical, and what might be in accordance with authority or in any conflict, we consider the kind of a relationship. See? In that case, underlings would work to support his supervisor or kind of a central branch in command about that public issues or others. Consider the branch offices dispatched by the unit located in Washington, D.C. The branch office might be located in New York and would be charged with some responsibilities about local administration. Then the norms and regulations need to be in comfort among another. In that case, the interpretive issue would arise. It kind of deals or in concern, especially many cases around 1940s, period shortly after the post-war administration. So emergency has gradually disappeared in the terms, but still many regulations would survive. So price control and what actually many issues on monopoly and some abuse of economic power and protection of a poor class. So consider, for example, the tie-in agreement. Or actually, the ceiling of price was set forth in the regulation, state regulation, perhaps in New York, or imagine many states in the United States. Then it should be respected Otherwise, some penalty, heavy fines or short imprisonment would be imposed as a matter of state regulation and state criminal law. Then the actor might avoid a direct effect from the statute or regulations. So they would avoid in such a way where the parties in contract would enter a tie-in agreement. And in purchase, in case of purchase of other related products, then the buyer will give a benefit of discount, kind of, and also in the ceiling for another product, the kind of arrangement would not directly contravene the terms of statute or regulations, but the tie-in agreement actually brings the same economic effect to avoid a regulation on ceiling a price. In that case, could we justify the criminal punishment? How do you consider? It poses difficult challenges, and many issues were dealt in the words. Well, a glib justification would often be encountered in cases. So what difficult was, and some technicality would pose challenges. What is the Latin word? Lascita associus, peri materia, express unis, adjudicem generis. Do I now correctly pronounce the words? These difficult Latin words are used in the codes or statutes around that period of time. I'm not sure if they were still in place of the code statutes. So it would provoke any difficult issues, and also contribute to have some straightforward ideas, since it is principled and actually so two ways of effect, difficult, and get us to have some bright line ideas, since it's traditional and principled. So these maxims would be used to interpret state regulations, but in many cases we would see it to be more precise, since the maxims would often involve the interpretation of statute or codes. As I stated, the code would not advance in thus farther. They would not be so serious about its legal characteristics. So that could be one purview when you undertake some sort in this province. In any case, we consider plain language rule or kind of ideas. Take an example of these words. Actually quite striking through the interpretation of regulations. So natural, for example, natural and most obvious simple. So the terms or phrases might be confusing, but we will get some better way to be related with interest parties when you talk about public issue, also plain language rules. And the normal concept is controlling. In other aspect, a little subtle, okay, in concern, you consider, for example, the law of maxims or the polish of regulations, and you also consider the fact what is patronized in interpretive practice, or actually administrative intent. That could be the points and the kind of tools to address the challenges from interpretive doubt of a regulations. I suppose those cases would assume the state regulations are law. In some cases, as I've suggested, the court would be dubious if they respect consistency and common application across the nations as a law. So more plausible evidence might change the shift, might change the true meaning of a statute, and they could not honor the precedent in other interpretations. So meaning could be different in this case. What does it mean actually? That would see a different classification, as I addressed. And you also, what final point? We'll take, well, actually